Yesterday, because of the coronavirus COVID-19 catastrophe, the Dáil in Ireland passed new legislation called the Emergency Measures in the Public Interest COVID-19 Act 2020. So today is Saturday the 28th, and it was passed through the Dáil on the 27th, Friday the 27th. There are emergency measures in this legislation. There are two significant parts of it, Part 7 and Part 8, which deal with employment law issues. And that's what I'm going to take a look at in this video. Before I do that, as a housekeeping step, the Act also makes provisions regarding the operation of the Residential Tenancies Act 2004, time limits in relation to planning and development, health and social care professions, the Mental Health Act, the Defence Act 1954, the Civil Registration Act 2004, and the Redundancy Payments Act of 1967. It's the Redundancy Payments Act 1967 and the new scheme for the temporary wages subsidy scheme, which I'm concerned about here. So Part 7 of this Act, the temporary or the Emergency Measures in the Public Interest COVID-19 Act, makes provision for a temporary wages subsidy scheme in Part 7. This scheme is the subject of two sets of Revenue Commissioner guidelines. The scheme, incidentally, has been the subject of quite a bit of criticism from some legal professionals, and I think from ISME or IBEC or some of the employers' bodies. That's fair enough, because the legislation was drafted fairly quickly. It is by definition emergency legislation, and this is a time when I think most people would recognise that speed is crucial and done is better than perfect. This, no doubt, is an imperfect piece of legislation, but with goodwill on all sides, and particularly given the commitment of the government and commitment of the Revenue Commissioners to make the temporary wages subsidy scheme work, then it's certainly worth consideration. I'm not telling you what to do or what you shouldn't do, but I am just flagging up the two pieces of legislation, or two parts of this legislation, which impinge upon employment law. So Part 7 deals with the temporary wages subsidy scheme. There are two sets of guidelines from the Revenue Commissioners. Some key points regarding the guidelines are: the employer must self-declare that he has been seriously impacted and that as a result of the coronavirus he will be unable to pay the normal wages. He wants to retain employees, and he will suffer a decline of at least 25% turnover or orders during the COVID-19 pandemic problem. So that's a self-declaration from the employer. Employer who has significant cash reserves, however, will be expected to pay a significant proportion of the employee's wages, even if he has suffered a decline in business. The 25% turnover calculation, decrease calculation, can be carried out on any basis that is reasonable. This addresses the question of the legalistic approach being taken by some people who described the drop in turnover or the inability to pay wages as being somehow a declaration that you're either fraudulently trading. That's what was being bandied about. There was another opportunity, or there was another alternative there, and that was reckless trading. But in any event, the Revenue Commissioners say that that is not going to be the case. That's not the view that they're going to take, and there is a certain element of emergency about the whole thing. The 25% turnover decrease calculation can be carried out on any basis that is reasonable. So that gives some comfort to employers. There will also be some supporting proofs required for the Revenue Commissioners. The names and addresses of employers availing of the subsidy will be published. This is a step that's been criticised by employers and by some legal professionals. However, as a taxpayer, if the taxpayer is essentially funding employers and paying the wages for employers, notwithstanding the crisis, I don't think it's unreasonable that the taxpayer is entitled to know who's availing of the scheme, because let's face it, it is the taxpayer's money. It is analogous, I suppose, and it has been compared with the publication of the revenue defaulters list. But let's face it, there is a world of difference between being a revenue defaulter and being an employer who comes to the situation with clean hands, who has been affected badly by coronavirus, COVID-19. Nobody is suggesting that that employer is somehow unworthy or unclean. And the very fact that names and addresses are published on the revenue website or on some website, some government website, as to who's getting the money, I don't think is unreasonable, quite frankly. As a taxpayer, I'd like to know where the money is going. There will be two phases, or there are two phases of this wages subsidy scheme. The one that started on the 15th of March and that runs to the 20th of April. And then there's a second phase which will run from the 20th of April with these new measures. And employees must have been on the payroll on the 29th of February 2020. It is a temporary wages subsidy scheme. The exact details of the scheme, the exact amount of money that is on offer, it's, I think, up to 70% and a certain limit, I can't remember off the top of my head, €480 a week or something like that, of the employees' normal wages. 70%, I think, is the subsidy from the government, but that's essentially for employers to keep employees on, not to lay them off, not to put them, or not to make them redundant, and it is a help. It's not perfect, but done is better than perfect. The second major change in this piece of legislation, this emergency legislation that went through the door yesterday, Friday, is to do with the redundancy payment scheme. So the Redundancy Payments Act of 1967 has a section 12 in it, which allows an employee who has been placed on layoff for a short time, after a certain period of time, 4 weeks, to claim redundancy. However, this piece of emergency legislation suspends that right, because employers had an understandable fear that a huge number of employees may, by reason of COVID-19 layoffs, make a claim for redundancy, in which case the employer would be in serious difficulty, would lose a huge amount of staff, would have a massive liability, and a large number of claims would then have to go through perhaps the various government departments and so forth. So the bottom line is the right to serve a notice for redundancy by reason of layoff for a short time has been suspended, and it has been suspended for the period of what's called, I think it's the emergency period, and it is anticipated. Yes, the emergency period is defined as from the 13th of March 2020 to the 31st of May 2020. So they are the two pieces of that particular legislation, the new emergency legislation, which impact greatly on employment law in Ireland. I hope you find this video useful. If you do, give it a thumbs up down below, and you may be interested in subscribing to my YouTube channel. On my YouTube channel, I do my best to explain in plain language various aspects of Irish law and Irish business. As I say, if you find this useful, give it a thumbs up down below. Thanks a lot.